Okay, so today what we're going to talk about is a lot of times clients come in and they want to say, okay, when we pass away, meaning a husband and wife, or if it's a single person, when I pass away, I want all of my hard-earned assets to go to my children, but I want it to go to them in the most protected way possible. And when we talk about protection, there's different types of protection that we're looking to give to the children or the grandchildren after the client passes away. Some of those protections are protections from estate taxes, protection from creditors, protection from divorces, protection from bankruptcies, those kinds of things. And so how do we do that? Well, a great tool that we have in our tool belt as estate planning attorneys is utilizing a revocable living trust and then creating what we call beneficiary trust, legacy preservation trusts that pop into existence after the trustors die. And so I think the best way to kind of explain it is a diagram and going through and explaining it as I diagram it. So basically how it works is clients will come in and say, okay, Dave, I'm going to create a trust. Typically the type of trust that we're going to create is a revocable living trust. That just means that the clients can change it, they can alter it, they can amend it, they could revoke the whole thing if they don't like it at any point in time. The main purpose for a revocable living trust is not to give us asset protection while the trustors are alive. A revocable living trust will offer zero asset protection while the trustors are alive, but rather a revocable living trust is created primarily to avoid something called probate. And all that is a legal process that we have to go through when either incapacity or death occurs and you own something and you no longer can manage that thing because you're either too incapacitated to manage it or you're dead and you can't manage it. The trust will avoid that issue by owning the assets instead of you, the person, owning the asset. So instead of people owning things, because people tend to become incapacitated and people tend to die, that's what forces these assets into a probate proceeding. We instead have the trust own the assets. Now, if the person becomes incapacitated or dies, there's nothing to go through probate on because the person doesn't own the asset. The trust does, and the trust doesn't die, the trust doesn't get sick, the trust doesn't go to the hospital, the trust doesn't get Alzheimer's or Parkinson's, and that's what helps us avoid this issue called probate. So the attorney will draft the trust, and then the client will transfer ownership of their assets into the trust. That's step number one. And then while the client is alive, they are the trustor of the trust, which just means the creator. They are the trustee of the trust, which just means manager of the assets in the trust. And as long as the client is alive and has capacity, they will be the trustee. They will be the manager of these assets. And then the client is also the beneficiary of the trust as long as they're alive, which means they can use all the assets in the trust. Now remember, if the client gets in a car accident and hits a school bus filled with attorney's kids, this trust will not protect these assets in the trust from that person's liability. They can take everything out of the trust in that lawsuit, okay? The trust doesn't give us asset protection. There's other things that can give us asset protection, but a revocable living trust does not do that. It avoids probate. That's its job. So during period number one, while the person is alive, the client, they are the creator, they're the manager, and they're the spender. Period number two is when death occurs. So when the client passes away, this is going to be death, then what we can do, something really fantastic and unique and awesome about a trust, not only will it avoid probate if we become incapacitated or die, but when death occurs, when the trustor, the client, has died, then we can draft the trust to say that these assets are going to go into sub-trusts for our children. Now, if we're married, this changes. If we're married, and one trustor dies, one spouse, then the surviving spouse just continues to manage everything. It's only when both trustors die, if we're married, that it then goes to our children. But in my hypothetical, I just had one trustor, one client, and that client has died. And when that happens, then the trust then will divide into these sub-trusts: legacy preservation trust, dynasty trust. They're all branded as different things, but they all serve the same objective or goal, which is to protect the inheritance for these beneficiaries. Let's make our math super easy, because I don't like math. And let's say that we have a $4 million estate when this client dies. The $4 million is made up of houses and cars and checking and savings accounts and all the stuff that they have. And we're going to give equally to our 4 children, which is $1 million apiece in this hypothetical. Well, instead of giving them their money free of trust, we draft the trust to say the money is going to go into sub-trusts, these legacy preservation trusts, instead of going directly to the child. So this trust will create a sub-trust for each of these children. And these sub-trusts are all drafted to protect that inheritance. So this trust does not give the client any asset protection from lawsuits and divorces and creditors and bankruptcies. But when the client dies and these sub-trusts are created for that client's children, these trusts do offer asset protection for the children. And so they can be drafted to do lots of really cool, neat things. The first thing it can do is make it so that if this child were to rear end a school bus filled with attorneys' kids, it can protect the inheritance from lawsuits. These sub-trusts can be set up so that if the child declares bankruptcy, they rack up a bunch of credit card bills or medical debt they can't pay for, then the money in that sub-trust can be protected in a bankruptcy. These sub-trusts can be set up so that if this child were to go through a nasty divorce, the ex-spouse does not get any of that money in the divorce. The divorce court has no jurisdiction over that sub-trust that that child is the beneficiary of. It protects it from that. The other thing it can do is it can be set up as what we call a generation skipping transfer trust, which what that means is the money that's in this sub-trust, when that child finally dies, 10, 15, 20 years after the client dies, if this sub-trust is grown to be worth $30 million, and then the child dies, we can draft this sub-trust so that none of that $30 million is subject to that child's estate taxation. It will skip taxation when that child dies, passing on that $30 million to your grandchildren with no estate taxes being taken out. Versus if I leave that million directly to the child when I die, and that million then grows to be worth 30 million by the time the child dies, then that 30 million is included in the child's estate for estate tax purposes, which means the IRS gets their pound of flesh. In this situation, because it's in a special trust that's drafted as what we call a generation skipping transfer trust, none of the growth that's happened in there that's in that trust when the child dies is included in the child's estate for estate tax purposes, which is a great, huge, wonderful benefit of these sub-trusts. And then these sub-trusts can continue on in perpetuity. So when this child does die, who's the beneficiary of this sub-trust, the money that's in there will pass on to your grandchildren and great-grandchildren and great-grandchildren on into perpetuity. In Arizona, we can do this for 500 years, that we can keep things in trust. So it's a great, huge, wonderful benefit to protect the hard-earned assets that the client has worked their whole life to achieve, making sure that it's not squandered or taken or wasted or taken in taxes when the child dies or when something bad happens to the child. So hopefully this helps you understand how these sub-trusts can work and how we can continue this legacy that the clients have put so much time and energy and effort into in perpetuity for a very, very long time.